What to do if a will or trust was changed? If your loved one unexpectedly changed a will or trust, you might be wondering, what do I do? Or perhaps a family member recently passed away and the property distribution was drastically different from a previous estate plan, or what you were told to expect. These types of situations are highly sensitive and emotional, especially if you're considering contesting the will or trust. Let's take a look at how best to navigate these processes. What's a will? Generally speaking, a will is a legal document that describes your wishes for the distribution of your assets after your death, including your real estate and personal property. It can also name an estate executor or personal representative and nominate a guardian for any minor children. The person who's creating a will is called the testator. The legal standards for will documents differ between the states, but every state requires 4 fundamental requirements. For a will to be valid, all of the following must be true. 1, the will must be signed and witnessed. 2, the will must show testamentary intent. 3, the testator had to be of legal age at the time it was executed. And 4, the testator had to have testamentary capacity at the time they executed it. What's a family trust? In general, a trust is a legal arrangement where one party, the trustee, agrees to hold legal title to trust assets and administer those assets for the benefit of another person, the beneficiary. The person who creates the trust by transferring their property to it is called the grantor, the settlor, or the trustor. A family trust is simply a category of trusts where the trust beneficiary or beneficiaries are your family members. 2 kinds of trusts that are commonly used in estate planning are testamentary trusts and inter vivos trusts, which are also known as living trusts. Testamentary trusts. Testamentary trusts are created by the grantor's will. The will establishes the trust, states what property should be transferred into it, and names the trustees and beneficiaries. Testamentary trusts are irrevocable and cannot be changed. Since they're not created, they don't come into existence until the grantor passes away. Living trusts or inter vivos trusts. Living trusts are established while the grantor is alive and generally remain revocable while the grantor is still living. Grantors usually can change those trusts at any time or revoke them entirely. Upon their death or incapacity, that revocable trust is going to become irrevocable. Can a will or family trust be changed? Yes. During a testator or grantor's lifetime, they're free to change their will or trust. To change the will, the testator may do one of the following. 1, revoke the previous will and issue a new one. Or 2, create a codicil, which is known as an amendment when it comes to trusts. A codicil is an amendment that changes the existing will without revoking it. After the testator's death, both documents, the will and the codicil, will be interpreted together when executing upon the plan set forth in the will. Codicils are typically only used to make a few small changes. A grantor may change a family trust during their lifetime by either changing their will or changing, amending, or restating the trust in its entirety. Once the grantor passes away or becomes incapacitated, the trust will become irrevocable and cannot be changed. What if a will or trust was changed due to undue influence or duress? If a will or trust was changed due to undue influence or duress, it can be deemed invalid. Undue influence simply means that a third party compelled or coerced the testator or grantor to change their will or trust. The influencer must exert an extreme level of pressure that overcomes the testator or the grantor's free will. Duress is a specific type of undue influence where the influencer uses physical force or threatens physical violence. Can I contest a new will, codicil, trust, or amendment? Potential, current, or previous beneficiaries and heirs can contest a new will, codicil, trust, or amendment in probate court based on claims of fraud, undue influence, or incapacity. To successfully invalidate a will or trust, the challenger must provide evidence that the document does not align with the testator's true wishes. Fraud can be shown where someone other than the decedent signed the document, or the decedent was tricked into signing the will or trust. Proving undue influence can be difficult, but contestants can provide direct and indirect evidence to support their case. Direct evidence shows that the influencer's actions overpowered the testator's free will. One example of direct evidence might be that the testator's caretaker withheld food until they changed their will to benefit the caretaker. Unfortunately, this type of direct evidence is often unavailable. However, indirect evidence can also be used to prove undue influence. Examples of indirect evidence that support undue influence findings include 1. The testator or grantor is at risk of being taken advantage of due to their age, health, or mental or physical capacity. 2. The testator or grantor is elderly and made dramatic changes to an existing document. 3. The property distribution in the new will or trust differs considerably from how the testator or grantor told people they planned to distribute their property or how it was presented in a previous document. 4. The property distribution in the new will or trust is unexpected and unexplained. 5. The property distribution in the new will or trust substantially differs from earlier versions of the documents. 6. The influencer had a dependent or confidential relationship with the person who created the document. 7. The influencer was present when the new will or trust was executed or was otherwise involved in procuring that document. 8. The influencer benefited from the document that they helped procure. Some states create a presumption of undue influence when a person with power over the testator helped obtain the will or trust at issue. In these situations, a contestant does not have to provide any direct or indirect evidence of undue influence. Instead, the relationship between the influencer and the person who created the document, plus the fact that the deceased left a significant gift to the beneficiary, creates a presumption that undue influence was exerted and the person benefited has the burden of proving the opposite, that there was no undue influence. Still, the contestant will need to file an action with the probate court to invalidate the document at issue, just with the benefit of the presumption working in their favor. When should I contact an estate attorney? Contesting a will or trust is a complicated process. If you believe that your loved one changed their will or trust because of undue influence, duress, or other unjust circumstances, you should contact an estate litigation attorney immediately. An experienced estate litigation lawyer can explain the most effective legal tools available to address the will or trust validity and your ability to get your rightful inheritance. And in many cases, the cost of that estate litigation attorney may be covered, in part or in whole. Have questions? Give us a call, shoot us an email anytime. Thanks for watching.